Additional funding is provided by the Idaho Public Television Endowment. You're watching the Idaho Supreme Court. Hardware and closed captioning for Idaho in Session is provided by the Idaho Legislature and Idaho Legislative Services Office. Additional funding is provided by the Idaho Public Television Endowment. You're watching the Idaho Supreme Court. Hardware and closed captioning for Idaho in Session is provided by the Idaho Legislature and Idaho Legislative Services Office. Additional funding is provided by the Idaho Public Television Endowment. You're watching the Idaho Supreme Court. Hardware and closed captioning for Idaho in Session is provided by the Idaho Legislature and Idaho Legislative Services Office. Additional funding is provided by the Idaho Public Television Endowment. You're watching.
Thank you. Be seated, please. Good morning. We are on record in case number 49693, Milus versus Sun Valley Company. This matter is set for rehearing at this hour on February 14, 2025. The appellant in this matter is Laura Milus, represented by Matthew Gunn. The respondent, Sun Valley Company, represented by Jacqueline Gans. Please note that Justice Brody is not with us this morning. She's absent but excused, and will listen to the recording and participate fully in this matter. Counsel, do either of you have anything before argument today?
No, Your Honor.
Very well, Mr. Gunn.
Justices, good morning. It is always an honor to appear before this court. I stand before you for a second time regarding the wrongful death claim of Ms. Milus and her stepson against the Sun Valley Resort, related to the tragic and preventable death of their husband and stepfather, Stuart Milus. Your Honors, this court got it right the first time, and it's a unanimous decision, and that decision should not be disturbed. This court's decision was clear, well-reasoned, and most importantly, true to the codified legislative purpose of Idaho's Ski Area Liability Act, which is to define those areas of responsibility and affirmative acts for which ski area operators shall be liable for loss, damage, or injury, and define those risks which the skier expressly assumes, and for which there can be no recovery. The Act's explicitly codified purpose could not be more clear that the Act is not an immunity statute, as much as Sun Valley would like it to be. I can't put it better than Justice Boyle put it in his Northcutt dissent when he said that the Act contemplates liability for negligence and does not give ski area operators total immunity. What this Act does is explicitly divide and apportion responsibility and liability between ski area operators and skiers. If the ski industry lobby, represented here today in full force, wants a full-blown immunity statute, that is between it, the legislature, and those constituent citizens of the state of Idaho the legislature represents. But this Act before us, as written and codified, the interpretation of which is up to this court, does not confer full immunity and carte blanche on Sun Valley, as it argues. Now, obviously, we're back here today because something in Sun Valley's petition for rehearing clearly got this court's attention. I'll address the arguments raised in that petition in turn, but the bottom line is this court, in its unanimous decision, did not get it wrong. I'll first address the standard of care issue, 6-1103 subpart 10. The court ruled that an ordinarily prudent standard of care applies to the enumerated duties of ski area operators set forth in that provision. This court got this issue exactly right the first time, based on two things: the plain language of that section and the fact that the Northcutt decision eliminating any standard of care was a plurality decision and thus non-binding on this court.
What about Long?
Thank you, Your Honor. There are two subsequent decisions that Sun Valley relies on, Long and Withers. Both Sun Valley argues that those two decisions independently and unanimously reached the same decision regarding 6-1103's standard of care language as Northcutt. That is wrong. That is inaccurate. That argument is incorrect. Neither the Long decision nor the Withers decision considered or ruled upon the standard of care applicable to a ski area's enumerated duties set forth in 6-1103. Section 6-1103's standard of care language is not discussed one single time in Long or Withers. The only two reported cases in the history of this court that discuss the standard of care language in 6-1103 subpart 10 are Northcutt and Milus. They are the only two reported decisions in the history of this court that discuss that language. Long and Withers stand for a different premise.
They do discuss, though, duties.
They do.
And I'm just wondering how you can slice things so fine that there's not a connection between duties and standard of care.
They do discuss duties, Your Honor, and I'll discuss in the context in which they do so. In both Long and Withers, the appellate plaintiff was arguing that he or she could bring a common law negligence claim outside of the Ski Area Liability Act. That was the issue brought in both Long and Withers. That is not the issue in Northcutt. That's not the issue in this case. We brought a claim under the Ski Area Liability Act. We don't argue that the Ski Area Liability Act doesn't apply. In Long, the plaintiff argued that he did not satisfy the Act's definition of a skier because he wasn't skiing on a designated trail. That was the issue in that case. He said, if I'm not a skier under the Act, the Ski Area Act doesn't apply. He tried to bring a premises liability common law negligence claim as a business invitee of bogus basin. He tried to go outside and around the Act. He said, premises liability, business invitee, common law claim, ignore the Act. The court rejected this argument. The court's ruling that his claim fell under the purview of the Act. So when Long states that the statute eliminates the common law standard of care, it's talking about preemption. It is saying the Act preempts claims by skiers against ski areas. But the critical point here is that unlike Northcutt, Long did not interpret 6-1103's standard of care language. I note that Sun Valley, in its brief in stating this proposition, it quotes a heading. It quotes a heading, not a substantive discussion in the Long case. It quotes a heading in the Long case that says, and I'll quote it, it says, the common law standard of care is eliminated by the skier statute. That's a heading. There is absolutely no substantive discussion whatsoever in any form or fashion regarding 6-110310 and the standard of care applicable under the Act. What Long is saying, with no discussion of 6-1103 subpart 10, is that the Ski Area Liability Act preempts the common law when it comes to claims by skiers, when it comes to skiing-related claims. That is not the issue before the court here today. Again, 6-1103 subpart 10 is not mentioned one single time in Long. It is the same issue in Withers. In Withers, the appellant tried to get around the act. The appellant tried to bring a common law negligence claim against Bogus Basin. In Withers, the appellant plaintiff tripped on a rope that was 30 or 40 feet from a disembarkation of a lift, tried to bring a common law negligence claim because the plaintiff argued that it was unrelated to skiing.
So again, kind of a premises liability?
Exactly.
Okay.
No one, I don't think anyone would argue or begrudge the notion that if I go up to Bogus Basin with my son and we trip down the stairs in the lodge getting food, that's a premises liability claim. It's completely unrelated to skiing, and the Ski Area Liability Act isn't implicated. So a plaintiff appellant in Withers was trying to bring that kind of argument, saying that this rope over here, even though it's on the mountain, is not related to skiing. And so they tried to get outside of the act again. And again, this court said, no, this thing's about 30 or 40 feet from the lift. It's designed to control flows coming on and off the lift. The Ski Area Act preempts the common law claim based on premises liability or common law negligence principles and said the act applies. But again, the absolutely critical point is Withers did not wrestle with the language in 6-1103 subpart 10 that this court wrestled with in Milus, that was wrestled with in Northcutt. Those are the only two decisions in the history of the state of Idaho to wrestle with that language. Long and Withers in no way, shape, or form reached the same conclusion as Northcutt in absolutely no manner. Those two decisions are not a reason to sidestep this court's decision in Milus, and they do not reach the same decision in Northcutt. Long and Withers stand for the simple and undisputed proposition that the act preempts the common law when it comes to claims for skiers against ski areas for skiing-related claims. But neither of those cases defines the act's standard of care under 6-1103 subpart 10. They don't even consider that language in any form or fashion. Again, the only two cases to do that are Northcutt and Milus. Sun Valley also raised an argument with regards to 6-1106, arguing that provisions, two words in 6-1106, the risks of skiing part of the statute, that two words in that section, plainly visible, in my case. Your Honors, I submit that this argument also should be rejected by this court based on two axiomatic principles of statutory interpretation that are critical to analyzing 6-1106. As this court said in Mosier versus Rosauer Supermarkets, when interpreting a statute, this court has an obligation to give effect to all the words and provisions so that none are rendered superfluous. We have to interpret the Ski Area Act to give effect to all the words put in by the legislature. Second, another just as critical basic tenet of statutory interpretation is that the more specific statute or section addressing an issue controls over the more general. Sun Valley's proposed interpretation of section 6-1106 violates both of these basic principles of statutory interpretation. Section 6-1103(2), which sets forth the duties of ski areas, requires a ski area to mark with a visible sign or other warning implement the location of any hydrant or similar equipment used in snowmaking operations and located on ski slopes or trails. That's the key language there, located on ski slopes or trails. Critically, section 6-1103 subpart 2 makes no distinction regarding whether the equipment is plainly visible or not. It doesn't say you only have to mark equipment that is or isn't plainly visible. It says you have to mark all equipment. So we have to give effect to those words in the statute that the Idaho legislature thought important enough to codify. We have to give effect to those words. 6-1103(2) requires a ski area such as Sun Valley to mark all snowmaking equipment, whether it's plainly visible or not. So how can we give full force and effect to both 1106 and 1103-2? I agree it's not the easiest question to unpack in language to decipher. But what we can't have is language in 1106 eviscerating language in 1103-2. If we interpret the two words plainly visible in 1106 as eviscerating the requirement to mark snowmaking equipment, whether plainly visible or not, we are writing that statute out of existence. We are rendering it a dead letter and a nullity. We can't have that under basic principles of statutory interpretation. So how can...
It strikes me your argument, though, is not about how we interpret plainly visible or plainly marked in accordance with 61103 sub 2. The argument you're making, to me, seems to go to how do we apply 1106, 1107, and 1109. 1107 says ski area operators are liable for violations of their duties in 1103, but they're not liable, I'm paraphrasing, not liable if the skier violates their duties under 1106. It strikes me your argument is essentially what happens if both of those are true, because I don't know how the language in 1106, plainly visible, can be construed as meaning the same thing that we have in 1103 sub 2. So it isn't what you're really getting at. If 1106 applies here, because it was plainly visible, but they also failed to mark it in accordance with 1103 sub 2, under 1107, how do we deal with that?
If I understand what you're saying, Your Honor, I didn't follow one part in there where you're saying plainly visible with regards to 1103-2. Can you clarify what you meant with that?
What I understand your argument to be is when we look at the language of 1106 and we interpret what does it mean to say equipment which is plainly visible or plainly marked in accordance with the provisions of section 61103, that we should construe plainly visible as meaning plainly marked in accordance with the statute. Is that what you're arguing?
I don't think that that's the argument, Your Honor. I think the argument is that 1106 covers different scenarios. I think that there is a way to harmonize 1106 with 1103-2 in the sense that I don't think there's any reading of 1106 that is intended to absolve the ski area of its duty under 1103-2. I think when you look really closely at 1106, it can, and keeping in mind the principles of the more specific governs over the more broad, 1103-2 is the more specific statute.
Why?
Because it's governing a much more limited subset. It only governs snowmaking equipment on trails. That's it. That's the situation we have, the factual scenario we have in this case.
But the situation is the two statutes govern different things. One, 1103 is talking about what are the obligations of a ski area operator. 1106 is talking about what are the obligations of a skier. And so I'm struggling with your argument that when we're interpreting what does plainly visible mean, we need to defer to a statute that deals with something different, which is what are the obligations of the ski area operator.
I agree with Your Honor that 1103 governs obligations of ski area. 1106, I think, talks about things for which a skier assumes the risk for, but I think the best interpretation of that language that you're citing, Your Honor, in 1106 is that it covers something different. I think that is the best interpretation. And what I mean by that, Your Honor, is the language in 1106, so comparing it again to 1103-2, which only talks about marking snowmaking equipment on a designated slope or trail. That's all it applies to. It doesn't apply to anything else. 1106 is broader. 1106 also applies to snow grooming equipment, and it applies to snowmaking equipment anywhere on a mountain without limitation to location. So I believe 1106, there are two parts to it, and they're designed to cover two different things. They are saying, in conjunction, these two parts of this key clause in 1106, they're saying, okay, ski area, and I think this makes perfect sense. You have no liability under two different scenarios under this clause in 1106. You have no liability if you plainly marked, if you marked in accordance with 1103, snowmaking equipment that is on a designated slope or run, that's what 1103 covers, so you have no liability if you complied with your duty. Makes sense to me there. And then it's saying, well, there's other scenarios of plainly visible snowmaking and snow grooming equipment, regardless of location on the mountain, that fall outside of the marking requirements of 1103-2. And 1106 is telling us, fairly I think, that if snowmaking equipment that is in a staging area by a lift or snow grooming equipment, which isn't covered under 1103-2, 1106 is telling us there's no liability for a skier running into one of those pieces of equipment that's plainly visible. I believe they are covering different scenarios.
And my struggle with your argument, though, is 1106 is all about what does the skier assume the risk of. It's not about ski area, you're not liable if this, and this. You get to that in 1107 and 1109. And one of my struggles here is we're talking about 1103 and 1106 in isolation, when it strikes me we have to interpret them along with 1107, which is what says ski area, you're liable if you don't perform your duties under 1103, 1 through 9, 10. You're not liable if skier violates their duties under 1106. And so when I look at that and I look at the fact that 1106 speaks exclusively to the assumption of the risk by the skier, and it says skier, you assume the risk for snowmaking and snow grooming equipment which is plainly visible or plainly marked in accordance with the provisions of section 61103, it strikes me it's telling the skier, you assume the risk in either scenario. And it's not saying, we're distinguishing the way that you're arguing it does.
I'm following your argument probably even better than I was initially, Your Honor. And though I'm following it better respectfully, I disagree with it. First of all, I'm going to assume for the sake of this argument here, obviously I know Sun Valley disputes whether or not they used a warning implement, but let's just say a ski area doesn't mark a snow gun in the middle of a beginner run. Okay, so 6-1107 says they're liable for any damage caused by the breach of that duty. So we jump directly from 1103 to 1107 based on the breach of the duty. No implication of 1106 there. But then, as I understand Your Honor's argument, you're saying 1106 interposes because of the plainly visible language. I think in order to interpret the statute to give a full force and effect to all the provisions, and also under the premise that the more specific controls the more general, I think the way to not render 1103 to a nullity, to write it out of existence in the statute based on plainly visible in 1106, is to interpret that plainly visible because it's in the clause with snowmaking and snow grooming equipment regardless of location, and because it's in the same clause as a reference to the marking of snowmaking equipment as required by 1103, that we can fairly presume that the plainly visible language is referring to something different than the 1103-2 marking requirements for snowmaking equipment in the middle of the run.
Counsel, before we keep going on this back and forth between 1103 and 1106, I just have a question. These are complex statutes, obviously. Some of the terminology is inconsistent. I'm just curious what your take on this is. In 1106, it refers to plainly visible, plainly marked. That's been repeated multiple times here today. A couple times, though, we've talked about 1103 as if it's purely reciprocal, but 1103-2 doesn't say plainly visible, it says visible, which is making me thinking, why is the adverb missing in 1103, but it's present in 1106? But then you go down to 1103-3, and it says the ski resorts are supposed to mark conspicuously on the top of the entrance. So again, I'm just wondering, I think we're supposed to assume that the legislature meant what they said the way they said it, and maybe not assume that's just an accident, but in your view, is that just an accident, or the different focus of these adverbs that appear in one that don't appear in the other, are we to take anything away from that?
Your Honor, I'll confess that you pointing that out is the first time I noticed that we use plainly visible in 1106 and visible in 1102 with regards to a sign or other warning implement. I think in all honesty, you don't have to convince me that this statute is, having wrestled with it for years at this point, is fairly inelegantly drafted. I couldn't speak to or say whether or not I think that there's an intent in using visible in 1103.2 and an intent in using plainly visible in 1106 or conspicuously in another part of the statute. None of these terms appear in the definitional section, which is 6-1102. And so,
I mean, as a layperson looking at it, might think, it might appear that it has to be plainly visible from the perspective of the duties of the skier, but from the perspective of the responsibilities of the ski area, they only have to make it visible, which seems like a much lower standard.
It does, Your Honor, and where we don't have defined terms, this court has said we have to use the plain, ordinary, and regular meaning of those terms. And so, beyond that, I couldn't offer a deeper explanation of plainly visible versus conspicuous.
Well, from your perspective, should we make anything out of that or not?
I don't believe we should make anything out of it. I think if something needs to be visible, plainly visible, or conspicuous, I do not think, if I'm a juror, I do not think, and if I'm told that there's a requirement that a sign needs to be visible or a sign needs to be plainly visible, in all honesty, I don't view that as any difference as far as what I'm trying to interpret. I would not be able to parse out a difference between something.
But isn't that the rub? If our prior decision suggests that some of these things are jury questions, that's exactly the kind of argument an attorney is going to likely, a clever attorney will likely make that argument in front of the jury, don't you think?
I think whichever provision of the statute we're talking about with regards to a given claim, I think those are the words that are going to have to be put in front of the jury. And if they aren't defined in the statute, this court's precedent says that it's the regular, obvious meaning of the words. And so, yes, I think to the extent 1106 is implicated at trial, plainly visible is going to be the words, and to the extent 1103.2 visible is going to be the words. But I don't think that I think that that's a distinction without a difference as far as the pure meaning of the words, but they would probably be the words that would have to be put in front of a jury when it comes to a jury instruction. I'm over the time that I wanted to reserve, but I appreciate the questions, Your Honors. Thank you.
Thank you. Ms. Gans.
Thank you, Mr. Chief Justice. May it please the court. I'd like to start off with our first argument put forth in our petition for rehearing, which is that 1106 acts as a complete bar to recovery in this case. I want to make something clear from the outset, however. Sun Valley is not contending and has never contended that this act is a full-blown immunity statute. We do contend that it provides or should provide significant protections for ski areas. But we are not taking the position that this is a blanket immunity act, and I think that's important. With respect to 1106, as we put forth in our briefing, we contend that this opinion either omitted the words plainly visible from the statute or improperly applied the qualifying clause in accordance with the provisions of Section 6-1103 to plainly visible. I agree with Mr. Gunn that this court has to give effect to all words of the statute. And respectfully, we believe that the opinion does not give effect to the words plainly visible in 1106. There is no dispute in this case and on this record that Snow Gun 16 was plainly visible here. And the court has seen the photographs. There's additional evidence in the record as well in the form of a investigator statement saying clear visibility, all snow guns were clearly visible. There is no evidence in this record that this snow gun was anything other than plainly visible. Now, that's not to say that in a different case, on a different record, and to your point, Justice Moeller, perhaps there is a question of fact as to whether a snow gun is plainly visible. There's no issue here, but in a different case, perhaps the snow gun is not in the middle of the run, perhaps it's off to the side of a run, partially obscured by some trees. I think that's a situation where there could be a question of fact with respect to whether the snow gun is plainly visible. But here, Under 1106, we believe that is the threshold inquiry that this court should undertake, and that's dispositive of the rest of this appeal. And if the court looks at this language and concludes that snow gun 16 was plainly visible on this record, it should affirm the district court's grant of summary judgment on this alternative basis.
And how do we square that with 61107 that says ski area, you're liable if you failed to perform a duty, you're not liable if the skier assumed the risk? And my question to Mr. Gunn is, what do we do if both are true, or if there's a genuine issue of material fact on whether the ski area complied with its duty?
I struggled with that question as well, Your Honor, and the way I've come to think about it is the assumption of risk analysis under 1106 is a separate and distinct analysis from whether a skier or a ski area breached either of their competing duties. We've made the argument strictly, for now, under 1106 assumption of risk, and we think that's a complete bar to recovery. I think that can be read in a non-contradictory way with the provisions you're referring to, because 1107 and 1109 deal specifically with duties of the ski area and duties of the skier. But that's going to be a different analysis as to whether or not there was an assumption of the risk under 1106.
But 1107 ties directly to 1106.
It does.
And 1109 ties directly to 1106. I mean, I'll be more blunt than Mr. Gunn. I think this is a poorly drafted statute. I think, as you've noted and I've noted, it conflicts. It internally conflicts. And so, you know, we've got 1107 that says the ski area is liable if they breach a duty, but it's not liable if the skier assumes the risk. We've got 1109 that says skier can't recover if skier assumed the risk. Both of those, when they talk about assume the risk or breach the duties, refers back to 1106. So how do we, it strikes me we have to construe 1106, 1107, and 1109 together, but they conflict. So how do we reconcile them?
Your Honor, I agree that the statute, there's significant room for improvement in terms of drafting. I don't believe, though, that these provisions conflict with one another. And I'm going to go back to my past example of a snow gun off to the side of a run, and I will walk through what I think the analysis might be and how these statutes interplay with one another. So, okay, we have the snow gun off to the side of the road. Let's say there's a question of fact as to whether, or off to the side of the trail. Let's say there's a question of fact with respect to whether it's plainly visible. So the next inquiry under 1106 would be whether the snow gun was marked in accordance with 1103. Let's say under our interpretation, the ski area took steps to mark that snow gun, put a visible sign on it, or a warning implement. If they did that, under our interpretation, there's no liability there. However, let's say the ski area does nothing, takes no steps to mark with a visible sign or a warning implement, and under that scenario, the ski area would be liable, unless the ski area may also have a defense that the skier breached one of his or her duties, and that is what caused the skier's injuries. And that is where you would look at the duties enumerated under 1106, right under the assumption of risk provision. And the skier, and this would likely be a question for the jury, because they would be tasked with determining, well, did the skier breach and did that cause the injury, or did the ski area breach its duties under 1103 and did that cause the injury?
What if they both contributed?
If they both contributed, Your Honor, I think the language of the statute is clear. If a skier breaches his or her duty, there can be no recovery.
And how do you square that with 1107?
Well, Your Honor, I can square it with 1107 if you look also to 1109, which indicates that a skier shall not be able to recover from the ski area for any violations of their duty. And I think this was, I think it's not only supported by that particular language, but I think it was also, that interpretation was confirmed in the Coughlin decision, which recognized if a skier breaches, and that was an unrelated case, as the court knows, interpreting a totally different statute, but the court said the legislature has already created a situation, a statutory scheme where this is not a comparative fault statute. And they said when a skier breaches, that skier cannot recover regardless of any breach, if any, by the ski area.
And what's interesting about the analysis in that case, though, is it focuses on 1106. It doesn't talk about 1107.
And Your Honor, my other response to that is I don't believe this court has to interpret 1107 to correctly decide this appeal.
But the title of the statute is liability of ski area operators. How is that not our starting point? It dictates when ski area operators are liable.
I think it could be a starting point in a different case where there has not been an argument that the skier assumed the risk. Here, where we do have the argument under 1106, I think that is the starting point. And where we have, on these undisputed facts, a plainly visible snow gun, none of the duties enumerated in 1 through 9 are going to obligate the ski area to make a plainly visible snow gun more plainly visible. And I think an analogy that can be drawn there is in the premises liability context, there's no duty to warn of an open and obvious danger. And I think the same logic could be said to apply here. There's no duty under 1103 to make a plainly visible snow gun more plainly visible.
So the first sentence of 1107 says, any ski area operator shall be liable for loss or damages caused by its failure to follow the duties set forth in sections 61103 and 61104, where the violation of duty is causally related to the loss or damage suffered. It doesn't say anything in the next sentence, which is they shall not be liable if the skier is acting in violation of their duties where the violation is causally related to the loss or damage suffered. I could agree with you if that second sentence said, they can't recover for any loss or damage if it is at all causally related, but the two sentences read together, don't they suggest that this may be a comparative fault regime? And that's why I'm concerned about the other cases, the two that have said it's not, and the fact that those two never interpreted this language in 1107. They don't even mention 1107. I agree if you read 1106 in isolation or you read 1109 in isolation, those would suggest if the skiers assume the liability, you're done. But then 1107 comes in and suggests, no, there's some liability if the damage is causally related to the failure to perform one of the enumerated duties.
And I think that interpretation, Your Honor, takes 1106 out of the equation altogether. And I think that would be an improper analysis because, again, we're not talking about a skier's breach of his duties in this case.
But wouldn't the comparative fault analysis not eliminate it? It would take it, the skier's breach or the skier's, I call it assumption of the risk because that's what 1106 calls it. Skier's assumption of the risk would reduce the ski area's liability.
Your Honor, I respectfully disagree. And I think, again, there probably could have been a different way of drafting 1106. But my read of it is that the first part is all about assumption of risk. And then in the same paragraph, yes, it goes on to enumerate the duties owed by the skier. Now, could that have been separated a little bit differently? Certainly. But again, I think the analysis for assumption of risk is going to be separate and distinct from the analysis of whether the skier breached. And I think that language in the second paragraph of 61106 is clear. Each skier expressly assumes a risk of and legal responsibility for the following. And so to interpret 1107 in the way that you're suggesting, I think would read out that language in 1106.
So, Ms. Gons, to that point, and first of all, thank you for giving us a second opportunity to take a look at this tough case. I'd like to hear your response to appellant's argument as reflected on page 14 of his reply brief. He uses an example. He says, if the skier is solely responsible for his injuries by operation of 61106, then the ski area is free to completely ignore its statutory duty to mark snowmaking equipment under 61103.2. And in other words, it may create some perverse incentive, or at least certainly won't encourage ski resorts to fulfill their duty. Could you respond to that?
Certainly, Your Honor, and thank you. I would respond with a couple of points. First, this court is constrained to apply the plain language of 1106, and it's for the legislature to question the wisdom or policy of that outcome. Here, I don't believe that the duty under 1103 has been at all eviscerated, because practically speaking, no ski area is going to cross its fingers and hope for a day with clear visibility and hang its hat on having a plainly visible snow gun on that particular day. So I think realistically the ski area is still going to take steps to follow all 9 of those enumerated duties. I want to make one additional point on this assumption of risk argument. This does present an alternative basis for this court to affirm the district court's decision below without wading into the murky waters of subsection 10, which I'll talk about. But we know that this court should not consider overruling precedent when there is another grounds for disposing of an appeal. And 1106 is exactly that in this case. Again, on this record, interpreting the plain language of that provision, Dr. Milus collided with a plainly visible snow gun, and therefore he is barred from recovery under 1106.
But don't we first have to address the district court's basis? I understand what you're saying about 1106, and had the district court reached 1106 and analyzed it, maybe we could start there and end there if we agree with your position. But in this instance where the district court said, I'm not going to address 1106 because I'm reaching it on straight 1103 grounds, don't we have to start there before we can move to 1106 as an alternative basis?
I think this court's opinion did already address that point and correctly found that while there was no lower court determination on assumption of risk, this court could still nevertheless decide that issue on appeal. And I completely agree with that, Your Honor. I'd like to next address the language under subsection 10 and what that means. Our position is that this court misinterpreted subsection 10 and concluded, contrary to the Northcutt plurality and later cases, that there is no standard of care for the duties enumerated under 1 through 9. I would contend that this court's interpretation of subsection 10 adds the word additional where it doesn't otherwise appear in that last clause of subsection 10. But I want to talk more so about what we contend is controlling precedent that this court has to follow under terms of stare decisis unless certain exceptions are met. I understand opposing counsel's argument that Long didn't decide what we believe it decided, and I disagree with that argument. Now, do I wish the analysis in Long was a bit more robust? Sure, yes, I do. But we have issue 2, which clearly states the issue that this court decided in its initial Milus decision. And yes, we do have a very clearly articulated heading, and that's great. But I am going to submit to the court that even if you take out that heading, the court can reach the conclusion articulated in that heading even if it wasn't there. So Mr. Long in that case did argue that he should be a business invitee who was owed an ordinary common law standard of care. And he wanted a reasonably accurate map, and he wanted a conspicuously marked trail. And the court did reject that argument. And in doing so, it noted, and this is the important part in that decision, that Mr. Long was arguing for a, quote, higher standard of care. And so the court in Long was acknowledging the fact that different standards of care apply here, and that the common law standard of care is a higher one than what the Act imposes on ski areas. Now, fortunately, this court doesn't have to take my read of Long as true, but it can look to the Withers court, which is useful because Withers confirmed and cites to Long specifically for the proposition that Long recognized the statute eliminates the standard, the common law standard of care. And so we do contend that those cases are controlling precedent, and that in turn leads to the follow-up question of whether they were manifestly wrong. Because of course this court...
Let me back up and
Sure.
push back a little bit on your interpretation of Long. So Justice Beislein wrote Long.
Yes.
He was the full-throated dissenter in Northcutt,
Yes.
that his interpretation of 1103 sub 10 is consistent with this court's interpretation. So my first issue with your assertion is he gives no explanation, and he doesn't cite Northcutt at all in his analysis in Long. There is no indication in this two-paragraph analysis that Justice Beislein is walking away from his dissent in Northcutt. So what causes you to think, particularly when he never mentions 61103 sub 10, that he is giving that interpretation to 61103 sub 10 in Long?
Your Honor, I realized late last night, that it was Justice Beislein who had the very spirited dissent in Northcutt, and now the very brief but unanimous authored opinion in Long. And I don't know what led him to change his position over the course of 4 years, but I contend, Your Honor, that it's clear not only from the heading itself, but again, I think it's implicit, at least implicit, if not explicit, in the analysis where he discusses that Long is arguing for a higher standard of care.
Right, and as Beislein states the issue, he states he, meaning Long, reasons that because he is not a skier for the purposes of the skier statute, he is simply a business invitee and is owed the ordinary common law standard of care, owed to a business invitee. And so is it your position that the common law standard of care owed to a business invitee is not higher or more robust than the specific duties laid out in 61103 and 61104?
I hope I'm understanding your question, Your Honor. I would say that the common law standard of care does apply in non-skiing related activities, and I don't think there's a dispute about that. And I do think that is a higher standard of care than what subsection 10 apply or means when it says any activities undertaken to eliminate, alter, lessen, or control inherent risks of skiing shall be deemed to impose no standard of care. So I do think that the common law standard of care is higher than no standard of care.
And my point is, you're attaching a lot of significance to Justice Beislein's use of the term higher standard of care. And my point is, the common law standard of care owed to a business invitee is a higher standard of care than the duties, the limited duties laid out in 61103 and 61104. So when he uses higher standard of care in Long, why isn't it simply a recognition that a business invitee standard of care would be a higher standard of care, but that's not what applies here in light of the Act, which limits the duties that a ski area owes to Long?
And again, Your Honor, I too wish the analysis added a little bit more. I can only point you to not just our discussion and in my interpretation today, but again, the Withers Court, which subsequently interpreted Long in exactly the way that we're advocating for, that it did eliminate the common law standard of care with respect to 1 through 9. Even though if this court does not agree that Long, as confirmed by Withers, is controlling precedent, I want to note briefly that, let's say the court does agree with that, there's been no showing by appellant that these cases were manifestly wrong. This court, as recently as last August, in the Genho versus Riverdale Hot Springs case, there was an argument there that past precedent was manifestly wrong, that Park West had interpreted a statute incorrectly. And this court noted that the appellant in that case did not meet the high burden required to overrule controlling precedent. And this court correctly declined to overrule or limit Park West because the appellant in that case did not make the necessary showing that this precedent was manifestly wrong.
Counsel, let's assume for a second that it wasn't manifestly wrong. Is it possible it was just sui generis? It's a case that's so different from other cases that we've decided under the skier statute that the court's focus was on different things. The arguments were presented differently. It didn't present the same kind of challenge to the ski industry that a case like this might. It was a different challenge under a different theory. And I'm just wondering if it's easier to say maybe it's inapplicable rather than it's manifestly wrong. It's sui generis, it's its own thing.
Well, Your Honor, I struggle with that. I don't think it's inapplicable. And I don't think it's inapplicable because, again, we have the Withers Court confirming this is what Long stands for. Long eliminated the standard of care applicable to duties under 1103.
Why isn't the statement in Withers simply a recognition that the common law standard of care owed to business invitees was supplanted by the Ski Area Liability Act?
And I'm sorry, Your Honor, your question is, well, let me go back to the quote from Withers. So the quote from Withers is, the common law standard of care with respect to non-skiing related functions remains, but the operator is absolved of the responsibility to protect skiers from the hazards of skiing except as enumerated in the statute. It cites to Davis, and then it cites to Long, parenthetical, recognizing that the statute eliminates the common law standard of care. Your Honor, that's a fair point. It's a great question. I want to shift gears a little bit because I think I've responded as best as I can as to why this court should recognize Long and Withers, and I want to make sure I discuss one other point. So we've also argued in our petition for rehearing that at a minimum here, subsection 10 is ambiguous and must be construed consistently with legislative intent. And so even if this court decides that Long is not the controlling precedent that we believe it is, we still have the Northcutt plurality decision and this court's prior decision interpreting subsection 10 in two opposite ways. And of course, I think reasonable minds have and do differ as to the interpretation of subsection 10. And so at a minimum, we believe that this court should determine that subsection 10, if it gets to this point at all, is ambiguous, and that the legislative history, which we've cited to in our brief, demonstrates that the intent of the legislature was to eliminate that standard of care or duties in 1103.
So how do you get there when part of the legislative history states in 61101, it is the purpose of this chapter to define those areas of responsibility and affirmative acts for which ski area operators shall be liable for loss? I struggle with a duty that's imposed with no standard of care is essentially meaningless. And, you know, we had some discussion in the first argument, I recognize you weren't here, about if you attach a teddy bear at the top of the run, that If you don't have a standard of care, that serves to fulfill a duty. And so how are we giving effect to the legislative intent to define areas of responsibility in affirmative acts if there's no standard of care to which the duty has to be performed?
Well, Your Honor, as I mentioned at the outset, we are not contending this is a blanket immunity statute. And while I would ordinarily be reluctant to stand up in court and attempt to enumerate the ways in which a client may be liable, I think that's actually instructive here, because I recognize that the court is struggling with how to interpret these provisions. When is a ski area ever going to be held liable? And there are a handful of situations where liability could attach. We don't dispute that. We have the common law standard of care for non-skiing related functions. Lodging, dining, parking lots, that's your standard, your common law standard of care. The teddy bear example, Your Honor, I think that is, of course, an absurd hypothetical to conceive of, but I think that is a situation where a district court could assess and say, was there a failure to follow 1103 sub 2, which requires, again, a visible sign or warning implement. And I think a district court could conclude strapping a teddy bear to a snow gun is a failure to follow 1103 sub 2. So I think there are situations where we are not contending that this is blanket immunity. There are situations that could give rise to a question of fact. Justice Mueller, to your earlier question about what do we make of these adverbs in various but not all portions of this act, I think, looking at 1103 sub 3 to mark conspicuously the top or entrance to each slope or trail. Now, that's not an issue in this case, but when you toss an adverb into a statute, I think the court does have to give effect to that word. And
it seems like they're picking and choosing. One place they say plainly, another place it doesn't have to be plainly. Here it has to be conspicuously, another place it doesn't. And I guess that kind of feeds into your ambiguity argument with subsection 10. If we're to follow your lead and take the path to ambiguity, that not only opens up the statement of purpose, but it opens up a lot of legislative history which appears to be all over the place. I mean, there's Senator Malik's and Representative Malik and Senator Davis's colloquy, statement by Representative Malik that the ski area would still be liable for negligence. I'm just wondering if that's going to make this a harder decision than just looking at the plain language of the statute.
Well, and I think the court can look to just the plain language of 1106, apply assumption of risk, the skier is barred from recovery, and call it a day. And that's primarily what we're advocating for. But if the court gets into the legislative history, I think the best evidence that this court had it right for so many years is the fact that the legislature could have amended subsection 10 in 2014, and it did not. And as we know, the legislature is presumed to know what the state of our law is. We had the Northcutt decision, we had Long, we had Withers, and it didn't touch subsection 10 in 2014. And I think that's instructive. I'm out of time. I appreciate the court's time and attention this morning. Thank you very much.
Thank you. Madam Clerk, how much time does Mr. Gunn have remaining? 7 minutes. Thank you, sir.
Thank you, Your Honors. I want to try to divide the remainder of my time between both 1106 and 1103 subpart 10, 1103 subpart 10. I'll start with 1106 and thinking more about your questions, Justice Zahn, that you left me with as far as how to read 6, 7, 9. Incredibly difficult. I think that the intellectual horsepower on this bench in front of me is incredibly impressive, but these are issues that don't present readily available or easy answers. But this is something that I discussed in my briefing below to the district court. I was trying to find the record site. I was not able to find one of my briefs where I talked about the potential applicability of a comparative fault regime as one potential way to try to give effect to all the words in the statute. And I don't think that that is an unreasonable path for this court to potentially go down, because we have 1109 telling us, 1107 telling us that a ski area is liable for damages caused by breaches of 1103. We have 1106 and 1109 telling us about skiers' assumptions of the risk. So in addition to my position that I stated during my first portion of this argument regarding my belief that 1106 is covering different territory, I also think some kind of comparative fault regime is one way this court could go. I understand the statement in Coughlin. I've read the statement in Coughlin. The interpretation of this act wasn't before that court. The Ski Area Liability Act was not before this court. I certainly think there's an argument that that statement in Coughlin is dicta when it comes to the overall gestalt interpretation of the Ski Area Liability Act. I certainly think that there's an argument because it's not interpreting, while it quotes 1106, it does not, Coughlin does not wrestle with 6, 7, 9, 3, all the different interplays and sections of 6-1106. And the only other point I want to raise with regards to 6-1106, and this somewhat goes to what Justice Moeller was saying about various adverbs in place in the statute. You know, we have the statement that it's undisputed that it was plainly visible on that day. I've looked at these photographs. Your Honors have looked at these photographs. It was a blue sky day. We have photographs taken a few hours after the incident where Mr. Milus unfortunately lost his life. And I know Your Honors have looked at those photographs, but to the extent we're wrestling with a poorly worded statute and we have plainly visible, there is no definition in the statute as whether or not that's plainly visible to, you know, in all honesty, I consider myself a fairly expert skier. What is plainly visible to me is not necessarily plainly visible to Mr. Milus, a completely novice skier in the middle of a crowded beginner run.
Right, but my struggle with that argument, Mr. Gunn, is when I go back and look at the record, I don't see where you submitted any evidence, including an expert who said it wasn't plainly visible. Your expert talked about it's not good practice to put the gun in the middle of the trail, but he didn't offer any opinion that this wasn't plainly visible. And when we look at the photos, it's right there. So how was it not plainly visible? It strikes me, I'm struggling to see how you created a genuine issue of material fact on that question.
Two responses to that, Your Honor. And first of all, with regards to expert testimony, this isn't a medical malpractice case where we're required to... And
I recognize that, but it's your burden to come forward with some evidence and create a genuine issue of fact.
I recognize that. And I don't disagree, Your Honor. Just making the point that, you know, the lack of expert testimony isn't fatal to the claim. It's the fact that the plain language of the statute doesn't say whether or not it's a subjective standard, whether it's an objective standard, whether it's a reasonable person of a certain skill level. It is in the record. I don't have a cite in front of me that he was a novice skier.
Right, but regardless of whether it's subjective, objective, you know, whether you're a novice or an expert, it's there. It's there in the middle of the run. It's the only thing in the middle of the run. How is it not plainly visible?
I think that there could be an argument to a jury based on his skill level, based on the crowd that day, that it would be up to the jury to decide.
And what evidence did you put in to suggest that there was evidence supporting that argument?
His ski level, the fact that it's a beginner run, and his level of skiing ability, Your Honor.
And who testified that novice skiers on that kind of run would not have noticed that gun, that it would not have been plainly visible to them?
We don't have expert testimony stating what Your Honor is saying right there. With the last 90 seconds I have or so here, I do want to touch back on 1103 subpart 10. We had a statement from opposing counsel that Withers reached the same conclusion as Northcutt, that it applied long. Justice On, I think you got this right. I wanted to point back to the citation too long in Withers, simply a parenthetical, a brief one, recognizing the statute eliminates the common law standard of care. Absolutely no discussion of 6-1103 subpart 10, application of standard of care to the enumerated duties in subparts 1 to 9. I think the best reading of that is that it's referring to the preemption that I've been discussing, that's referring to the elimination of the common law standard of care when it comes to skiing-related claims. I think that's the best interpretation there. I do not think Long or Withers in any form or fashion reach the same conclusion as
Is Section 10 an example of where the exceptions swallows the rule? I mean, we have 10 words at the beginning of Section 10. Not to intentionally or negligently cause injury to any person, semicolon, provided. And then we have 70 or 80 words, which would seem to undercut everything that was said in the first 10 words.
That's apropos, Your Honor, because that was the quote I wanted to leave this court with, was we're talking about legislative intent and legislative purpose, and the first 10 words of 6-1103 subpart 10 state that a ski area, one of their duties is not to intentionally or negligently cause injury to any person. I love that language, and it highlights that this is not an immunity statute. But more to your specific question, Your Honor, I think this is Justice Beislein's dissent in Northcutt, and I think it's this court's decision in Milus. I think the absolute best reading of this statute, the 9 enumerated duties, is that there is an ordinarily prudent person standard of care that applies to these 9 duties. And then if a ski area wants to go above and beyond, that's commendable. If a ski area wants to go above and beyond these 9 enumerated duties and do more for safety of its skiers, that is commendable, and it's fair to not hold them to a duty of care, because more safety efforts are better than 0 additional safety efforts. And so I think it's forward-looking.
Your time is completed. Thank you. With that this matter will be under advisement. We'll render decision again with Justice Brody's involvement. As I noted, thank you very much. We are now in recess until April 2nd, 2025.
You're watching the Idaho Supreme Court. Hardware and closed captioning for Idaho in Session is provided by the Idaho Legislature and Idaho Legislative Services Office. Additional funding is provided by the Idaho Public Television Endowment. You're watching the Idaho Supreme Court. Hardware and closed captioning for Idaho in Session is provided by the Idaho Legislature and Idaho Legislative Services Office. Additional funding is provided by the Idaho Public Television Endowment.